Hello everybody, it's Rick. I'm going to do a video. I'm going to be showing you some good case laws, and I'm going to tell you how to use the case laws. What you do is, anytime you make a statement in your order or your notice to the court, you want to back it up with a case law. So like, as I was showing you, I did an order to show cause stamped on September 4th, and I submit evidence, and I'll make a statement. I'll say evidence submitted on September 6, 2013, Exhibit Mark B. Exhibit A. Exhibit B. This is that void judgment issued on July 24th by Sudeep Kaur, and that's what my order to show cause is about. But what I'm stating is that the copy of the order on September 24th, 2000 is proof by referencing retroactive increase. This maniac increased my child support retroactively. I think anybody follow my videos, they know that this maniac, I was paying $697. I already paid it, so it's in the bank. It's done. You can't unprove it. Like my ex-wife could go to court saying he wasn't giving me enough. $697 is plenty. But I keep telling you, this is all. I'm just proving these courts and family court are nothing more than to get you to pay support through their child support enforcement agency, so they can collect 66 cents on every dollar. That's what it's all about. That's why all of these men who are divorced or men who are getting divorced, why are they asking you if you want to pay child support through the support collections unit? Or let's say, like in my case, I waived it, and then I go to court on June 7, 2012. This Sudeep Kaur, she goes and asks my ex-wife, "Oh, do you want child support paid through support collection unit?" And she's like, "Yeah." And I'm like, "No." And like, what was the reason for that? Because there was never any issue of me paying it. I mean, in Kaur's void orders, she stated it's not. Richard Wyman has made supplied proof that he made payments, but it's because they want to make this money. Picture every payday. Because this is how slick they are. They're actually committing a federal crime under the Federal False Claims Act. What they're doing is they'll show all this money they collected. There's in 2011 I found not in 2011, a couple of years ago I found an article from 2011. It was like a New York magazine or something, where it was like, they were bragging about how their new efforts to collect child support from deadbeat dads, they got to put us down, calling them deadbeat dads, because, while you're perpetrating a crime, you got to deflect. You got to make us the criminals and not you the criminal, the child support New York State agencies who are really the criminals. So they'll say the deadbeat dads. And what it was they were bragging about their income withholding orders. So they stated in New York City, now New York City is probably the 5 boroughs, Queens, Brooklyn, Manhattan, Staten Island, the Bronx. They collected in 2010 or 11, $670 million. Now, what is 66% of that? It's about $450, or at least $400 million. So they made $400 million just from collecting child support by income withholding orders. You know how many jobs that is? Do you know how many bonuses that is? Do you know how many lives are ruined by those things? By bank accounts being frozen? Guys living in basements and these criminals, so that's why they do it. So that's why it's important that when you issue your orders, or when you fight these people, you make them as uncomfortable as possible by supporting everything with case law, with constitutional law, Supreme Court cases, whatever state you're in, citing appellate and appeal courts decisions, because it's going to be very hard for them to explain why they were doing it. And you're gonna, if you want your money back, everybody you have to be ready to sue these people in federal court. And if you watch my videos, I'll tell you how to do it. It's not that hard. I've been doing it, and I'm doing okay. They're trying to get rid of me. What I'm trying to do is, I'm trying to be, and this is what you could do too. I'm trying to be such a pain in their butt that they to just get rid of me. I'm waiting for a phone call one day to just say, hey, what can we do to make this go away? Can we make an agreement? And I'll be like, yeah, sure. But then I also want to be compensated for all my pain and suffering. There's no reason why I cannot get my money back and be compensated, because there's in the Constitution, they're allowed to take your money for public use without compensation. Now, if they're stealing your money for child support and getting 66%, isn't that for public use? Absolutely. Because that money that they use is used to balance all their budgets and state budgets. You think that $400 million they're getting is just for child support? No, that's for who knows what they do with that money. I can't even imagine how many phony companies are set up because from these people that are connected with state government and the federal government. So anyway, what I said here was, and I backed it up, I said that the order was void because in New York State, any order of support before the date of October 13, 2010, you just don't go to, what they've done is when you go to court, they focus everything on you. That's why they want your pay stubs and everything. Because as soon as you have an increase in salary, they automatically increase your child support. No, that's not how it's supposed to be. It's supposed to be based on an unanticipated and unreasonable change of circumstances, and that's it. So whoever petitions the court has the burden of providing evidence, not you. And you could just show up there. That's what you're supposed to be able to do. We know it doesn't happen that way. You're supposed to if you really just show up there and not utter a word and just cross your hands and arms and just stand there. But here's a case law that I used to back up my statement. Now this is a very good case law. It's huge. So anybody watching my videos, write it down. I apologize. I don't do videos like other people that you actually see the screenshot. I don't know how to do that. Not yet. One day I will. I'm too busy fighting these people right now. So it says, and it's a matter of Bowden versus Bowden. It's like a landmark case in New York State. Okay, they use it all the time. So it says, for agreements executed prior to the effective date of the amendment of Family Court Act 451, the standard for modifying an order based on the parties' agreement is whether the petitioning party has demonstrated an unanticipated and unreasonable change in circumstances, or that the children's needs are not being met. That's huge, that last one. The needs of the children not being met. You know how hard it's going to be for a woman to prove that? That's a lot of money to get. All right? So that's how you use a case law to back up your statement. Now, here's how I did it again. So I make a statement. Writ of quo warranto is under 28 U.S.C. 69 All Writs Act, demanding sue deep car to vacate all support orders under docket number blah blah blah. Show evidence and power, evidence of power and jurisdiction provided by the evidence introduced by Bridget R. Dolphin on December 20, 2012, financial disclosure affidavit showing an unanticipated and unreasonable change of circumstances causing the needs of the Rwandan children not being met, authorizing Queens Family Court Judge Fran L. Lubau and Sudeep Kaur the jurisdiction to remedy this redress by modifying the terms of a stipulation of settlement agreement back in 2007. Therefore, without this evidence, all orders created by Sudeep Kaur are void for lack of subject matter jurisdiction. Now, here we go. Bowden versus Bowden. Here's another good case law. Klyla versus Klyla. Now, if you're a married guy watching my videos and you have a stipulation of settlement agreement, this is a very important case law, so get ready to write it down. Okay? Because family court has no jurisdiction to enforce or modify issues or terms in a stipulation settlement agreement. Okay? Actions instituted to enforce a separation agreement as opposed to those actions seeking support within the meaning of the jurisdictional statutes or constitutional provisions pertaining to the family court. Now, where does family court get their power from? The New York State Constitution. That's it. So now, see New York State Constitution, Article 6, Sections 13 and 19 is the surrogate court. But Section 13 states very clearly that family court has no jurisdiction for New York State divorces, incidental, child support cases incidental to New York State divorces. So if you're divorced and you have and your ex is making allegations for child support, you have absolutely no business being in family court. None. They don't want you to know that, though. I'm still fighting this criminal over this. She keeps going, well, the Constitution, the jurisdiction is stated in your agreement. Because the agreement has this term or whatever, this provision that says, family court shall have concurrent jurisdiction with Supreme Court as permitted by law. Well, the New York State Constitution law doesn't permit it, so that's it. So a piece of paper couldn't give this woman, that's what I've been arguing with this dingbat about. All right, so what this case law is stating is that the New York State family courts have no jurisdiction in New York State divorces and stipulation of settlement agreements. Also, stipulation of settlement agreements are private contracts. Okay, and New York and family court has no law and equity jurisdiction to enforce contracts. None. At all. So anybody watching my videos who is divorced and getting screwed over, and you have a stipulation of settlement agreement, you have no business being in family court. Here's another big case law called Brescia versus Fitz, and another case law probably cites it. The family court is a court of limited jurisdiction. You know what that means? That means it's an inferior court, and is without the power to set aside or modify terms of settlement agreement. That's it. Now, I've cited all these things, and they're still trying to play games with me, but I'm getting somewhere. But that's how you use case laws. What I'm going to do is I have a whole bunch of case laws here. I have a piece of paper, for constitutional case laws that you can cite. Like a famous case law, everybody I'm sure who watches Law and Orders all the time, or whenever you watch a cop show, what do the police, they always do? You have the right to remain silent. Well, you know what that is? That's Miranda. That's a famous case law. And it's not just for when you get arrested. It means that any rights secured by the Constitution, there shall be no rulemaking to abrogate them. Okay, so if you have a right to a trial by jury, they can't go and create a rule or procedure in family court where, like, yeah, you know what, we don't do trials here. Well, then guess what? You're violating my rights. All right, so that just gives you a quick breakdown of how you're supposed to use case laws to back up a statement. Because and that's the same thing with any lawyers, by the way. Whenever they make these statements in court, they got to back it up with evidence. So, like, if some lawyer's going on in family court, what you do is you object. You go, objection, clarification of evidence to support the last statement. And then he's supposed to say, well, and then you got him. Well, if there's no evidence, you're just making a statement. It's unsworn, and it's not a fact before the court, as per case Trinzi versus Pagliaro. All right, I'm going to shut this down for a little while. Anyway, use those case laws. Write them down. Anybody that you can use them when you go to court. All right, they're all over the family court, and any you just go keyword and you'll see them all over these lawyer websites who claim they're going to help you, and they're like, well, we can help you because of these reasons, but they never use them. Anyway, enjoy the rest of your day.